Expressive interpreting.
Picking a jury.
1 minute warm-up. Begin expressive interpreting.
A friend of mine just got called for jury duty and was excited about it. A friend of mine's mom has been on several jury duties and loves the experience. Other people have a different reaction. I've had calls from people asking me to help them get out of jury duty. You will be called at some point in your adult life to be on a jury if you are registered to vote, if you have registered a car, if you have registered property. Different states have different ways on which they use a pool to pull people in for jury duty. Usually you'll be receiving a notice in the mail that summons you to jury duty. It is an order of the court that you need to obey. They will have information nowadays to call in or check a website to see what your particular day is. Juries are called in both federal court and in state court. State court those are the courts that administer disputes in your individual community under your state law. Federal court involves different types of federal laws or controversies between people in different states that exceed $75,000 or involve a federal question. Juries are used in both civil courts and criminal courts. I'm not sure if I just said that, sorry. Anyway, you will get a notification. It's an order for you to appear on a particular day. There are grand juries for which you could be summoned, and there are petty juries. Petty juries are the traditional jury duty that everyone talks about. A grand jury is a special jury that is called, and they meet over a longer period of time, maybe once a month, once a week for a period of so many months. And those are usually in federal court. They could be in state court. Those concern indictments and criminal matters. And prosecutors will bring in evidence to show the grand jury over a period of time. And you probably heard about it on the news where the grand jury voted and returned an indictment. And that's what starts a criminal matter. So that's one type of a jury, and that continues over a longer period of time and can involve multiple cases. A petty jury is what a traditional person saying, "I've got called for jury duty," is referring to. And that is a jury of 12 people. In some cases, it could be 9 or 6, depending upon where you live and the rules of that court. And it is concerning a controversy between people, or people and companies in a civil matter, or it is involving a criminal matter, also in state or federal court. One misconception, people talk about getting picked for jury duty. You'll be chosen from the pool of eligible people to be called in for jury duty. That's really the only picking there is. I'll let you in on a secret. You're not picked. The attorneys are not there to pick you. They're actually there to do the opposite. While it may end up that somebody is more favorable, it's not a vote that the attorneys say, I really want this person. What happens is they say who they don't want. And it's through a system of challenges. First, the people who come in and are assembled that are all called for a particular case or on a particular day, that's called the venire. That is just the group of people from which one or more juries will be called. Sometimes you'll report to a court. More and more they're getting organized, and so all the jury trials will be held starting on a particular day. So all the people that are brought in can be parceled out for different cases in the courthouse. It's just a little bit more efficient, and that way people don't waste their time coming in for one case and then those people are picked and then they have to leave and come back again. So you have the venire, which is the big group of people. Then there is depending upon the type of case, the notoriety of the case, the pool, the venire will be bigger or smaller. And sometimes you also hear in the news about jury selection going on for days and days. That is because of the process that then unfolds as the attorneys for the different parties involved ask questions to try to determine who might be unduly prejudiced against their party or their case, that they would not want them on the jury for their own purposes, because they want to win, but also overall for error, for prejudice, and things like that could cause the whole trial to be upset and have to begin again. So they want to get the best people on there for their client in general, for people that aren't going to unduly favor another party or the state if it's a criminal matter, and go through that. So you have the venire. The people are sitting down, assigned a number in alphabetical order. There are usually questionnaires that the attorneys get so they know who the people are, their educational background, their work, and some of that information. Sometimes you get that well in advance, a couple of weeks. Sometimes you get it that day.
Expressive transliterating. Picking a jury Part 2. 1 minute warm-up. Begin expressive transliterating.
That day. So if you see people scrambling around making charts and graphs, that's why they have to try to keep track of the people. Next is the voir dire, and that is the period where the judge introduces the attorneys and the parties, and then the attorneys for each of the different parties has the opportunity to address the panel, to address the venire, to give information and to mostly get information back from the people. And that's how they determine who they might make a challenge against. There are challenges for cause. If you are called in here's your tip for today. If you are called in a criminal matter and there is a question posed to you about a particular type of case, maybe it's a burglary, maybe it's a murder, maybe it's a child molestation case, it could be a petty theft, and they ask you your opinions about certain types of crimes, your opinions about the police, your opinions about certain part of town. If you have an inbred bias, not inbred, but if you have a bias against something where you believe that everyone who's arrested is guilty, and that is something that you cannot be swayed away from, that you cannot have an open mind against the person who is being charged if it's criminal, or against these two companies. If you are anti-corporate America and there's a corporation involved and you just believe that they are terrible and that you just don't like them and you don't trust them, you only like small grocery stores and local people that you know, anyone else you're suspicious of, and for that reason you could not be fair and impartial in your evaluation of the information that's brought to you in that trial only, that you would still be influenced by outside influences, your upbringing, your religion, your neighborhood, your family, and you would not be able to apply the law that will be given to you and to the facts in the case and render your decision, your vote with the other people. If you say that I could not be fair and impartial in this case, somebody is going to strike you. And so those challenges are for cause, which would be that situation. Somebody is the mother of the prosecutor. Somebody is the mother of the defendant. Somebody is the mother of the judge. That's going to be a cause. Strikes for cause are unlimited. Then you have peremptory strikes, and those typically are 3 per each party. Sometimes there will maybe more in certain situations, but those are established before the people come in for the panel. So they take turns. The attorneys take turns after the questioning is done. The veneer, the people leave the room sometimes, and they most of the time, and then you do the challenges and challenge the judge considers those for cause first. This is all on the record before the court reporter. That's why you leave the room. Nobody's trying to insult anyone, and it's just a matter of procedure, but they have to have it on the record, and they don't want anyone embarrassed. So the panel is removed from the room. The judge talks with the attorneys, and they go through the cause first. Then they go through peremptory challenges and pass those around, and then they usually look at the people who are right in front, if you've given a number, 1 through 12, and then depending upon the case, they'll have one or more alternates. And then it's just a matter of elimination. Whoever in that first group is not eliminated, it's going to be those 12 that are left. Everyone comes back in, and the judge announces who will be on the jury, and there you go. You're usually given some type of a small stipend, and maybe a parking allowance. I'm not sure. Once the trial begins, then I believe in most places then you're provided lunch, things like that. The first day, don't count on anything. If you've got a pillow that you need to sit on, bring that. Bring a book, bring your iPad, something like that. And then going forward, you may or may not be able to take notes. You're not going to be able to talk to the other people on the jury during the trial until you start to deliberate, because you're not supposed to make any judgments until all of the evidence has been submitted. Then at the conclusion of the trial, you will receive instructions from the court. Those were prepared by the attorneys in advance. Those were argued about and finally determined by the court as to what you would receive. They will be given to you in writing, and those are the instructions, and that is what the jury uses to make the ultimate decision, because the rules and what the different things they have to check off and determine are on those pieces of paper. And I'm going to do a couple of videos on some recent jury verdicts and things where people were all up in arms about how could the jury act this way or that, and I'm going to give you some of the information on why some of those went a different way, and it wasn't necessarily properly reported or accurately reported by the news. Anyway, so that's my editorial, but you will get the instructions, and then there is a verdict form. Going into the deliberations, the jury will select a foreperson who will be in charge of keeping order and running the votes.
This is the end of the 2 sections.